أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. إن الحمد لله نحمده ونستعينه ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا. إنه من يهدي الله فلا مضل له ومن يضلل فلن تجد له وليا مرشدا. والصلاة والسلام على أشرف المرسلين سيدنا محمد وعلى آله وأصحابه وسلم. We give thanks to Almighty Allah for giving us the opportunity to commence this special Islamic Finance Dialogue series, which is specially dedicated to this month of Ramadan. We pray Allah subhanahu wa ta'ala to accept this from each and every one of us as an act of ibadah. Part of the ethics and etiquette of Muslims, which we want to be uploading at MUNFIQ Academy, is that of keeping to time. When we say we want to start a program at any particular time, it is expected of Muslims that we keep to time. Alhamdulillah that we are able to do this just as we have been able to do in respect of our other program. So this will give a clear message to all our participants in our subsequent programs that when we say 10 o'clock, our 10 o'clock will always be 10 o'clock, inshallah. So without further ado, so we begin in the name of Allah, the beneficent, the merciful. Allah, the only one worthy of worship, we give thanks to him and we thank him for all the favors he has bestowed upon us. And we begin in his name. We pray Allah to accept this effort from each and every one of us as an act of ibadah. We want to welcome each and every one of you to this special Islamic Finance Dialogue. And by dialogue, we know that it has to do with deliberation, reflection, discussion, and even we reflect on a lot of issues. So today, we are going to be reflecting on one of the very important issues that affect the life of every Muslim. That is matter of inheritance. We all know that inheritance is well stipulated in the law of Allah, which is Shariah. But there could be some challenges where people will not be able to enjoy and claim their rights of inheritance. One of such things, which because we have found ourselves in a country where we are also subject to another system of law, which is called common law. And those that help people to claim their rights, they are lawyers. So they are trained majorly in the common law system. And one of the things that the common law has taught them is that if somebody sleeps on his right for a certain period of time, it will become impossible for that person to claim that right any longer. Notwithstanding that that right may still be very well possible to be established even by evidence. But because that person has allowed a long time to pass without pursuing that right, it becomes extinguished. So in light of that, we want to deliberate on the perspective of Islamic law on this very common principle which lawyers, or let me say techniques, which lawyers use in winning cases for their clients in denying rights to those that are ordinarily entitled to it, which is called statute bar. So what is the position of statute bar generally in Islamic law and specifically in relation to inheritance rights? So this is the focus of our dialogue this morning. And as you are aware, we have invited very eminent and competent scholars who are specialists and researchers in this field to come and share their thoughts with us so that we'll be able to have a clear understanding of the position of the law of Allah on a matter like this. And we pray Allah to make it easy for all of us and make it beneficial for each and every one of us. Just before we proceed, let me briefly read out the rules of this dialogue. And inshallah, the dialogue will last for a duration of 2 hours, inshallah. Then the participants' audios and videos are muted for decorum, as you may observe. So all attentions while the dialogue is in session should be raised through messaging in the chat box. Participants can raise hand during question and answer to make their contributions. So we want to appeal that we should not click the hand raising symbol while the session is ongoing, so that we avoid the distraction. So participants are required to fill the attendance form before the close of the dialogue to be eligible to certificate of attendance. Inshallah, no post-dialogue complaints or requests will be entertained. So the link to the form will be shared in the chat box at the appropriate time towards the end of the dialogue. So each participant will receive certificate of attendance within a week after the dialogue. So we need to clarify this so that people will not start asking us and sending us messages asking for the certificate immediately after the program. So give us a week for us to process the certificate of attendance. So guest speakers are kindly requested to open their videos when speaking. So they will be made a co-host to do this when it is time. So these are the rules that we guide this dialogue. And we start, like I said, in the name of Allah, the beneficent, the merciful. And we have also spelled out the schedule of activities during this session of the dialogue, allotting minutes to each of the activities that we are going to be undertaking. Please, we want to appeal that those that are writing, clicking on the screen being shared, should please stop doing that so that you not disrupt what we are sharing here. So now, from the schedule of activities here, so we are going to have the opening remarks and dua, which is exactly what I've done now. But just to fulfill some kind of order of protocol, so we want to commit this session to Allah, and we pray that He guide us and give us a very successful dialogue session. So I'll be calling on a brother to give us an opening Quran recitation. Let me confirm if it's here so that I will enable him to unmute. Please, I hope you join with your name so that it will be easy for me to trace you. Is Brother Sultan here? So if you are here, you can raise your hand, please, so that I can unmute you to give us an opening recitation from the Quran. Okay, in the absence of that, let me quickly use the other alternative we have put in place. Just a moment. Okay, so inshallah, we'll be listening to recitation from the Quran from Sheikh Abdullah Ali Jubairi. Bismillah. Bismillah.
كان عليكم رقيبا وآتوا بالطيب ولا تأتوا أموالهم إلى أموالكم إنه كان حوبا كبيرا وإن خفتم ألا تقسطوا في اليتامى فانكحوا ما طاب لكم من النساء مثنى وثلاث ورباع فإن خفتم ألا تعدلوا فواحدة أو ما ملكت أيمانكم ذلك وأحسن صدقته مثله فإن طبن لكم عن شيء منه نفسا فكلوا هنيئا مريئا ولا تؤتوا السفهاء أموالكم التي جعل الله لكم قياما وارزقوهم فيها واكسوهم وقولوا لهم قولا معروفا وابتلوا اليتامى حتى إذا بلغوا النكاح فإن آنستم منهم رشدا فادفعوا إليهم أموالهم ولا تأكلوها إسرافا وبدارا أن يكبروا ومن كان يستعفف ومن كان فقيرا فليأكل بالمعروف فإذا دفعتم إليهم أموالهم فأشهدوا عليهم وكفى بالله حسيبا للرجال نصيب مما ترك الوالدان والأقربون وللنساء نصيب مما ترك الوالدان والأقربون وللنساء نصيب مما ترك الوالدان والأقربون مما قل منه أو كثر نصيبا مفروضا وإذا حضر القسمة أولو القربى واليتامى والمساكين فارزقوا منه وقولوا وليخشى الذين لو تركوا من خلفهم ذرية ضعافا خافوا عليهم فليتقوا الله وليقولوا قولا سديدا إن الذين يأكلون أموال اليتامى ظلما إنما يأكلون في بطونهم نارا وسيصلون سعيرا يوصيكم الله في أولادكم للذكر مثل حظ الأنثيين فإن كن نساء فوق اثنتين فلهن ثلثا ما ترك وإن كانت واحدة فلها نصف ولأبويه لكل واحد منهما السدس مما ترك إن كان له ولد فإن لم يكن له ولد وورثه أبواه فلأمه الثلث فإن كان له إخوة فلأمه السدس بعد وصية يوصي بها أو دين. آباؤكم وأبناؤكم لا تدرون أيهم أقرب لكم نفعا فريضة من الله، إن الله كان عليما حكيما. ونصف ما ترك أزواجكم إن لم يكن لهن ولد، فإن كان لهن ولد فلكم الربع مما تركن من بعد وصية يوصين بها أو دين، ولهن الربع مما تركتم إن لم يكن لكم ولد، فإن كان لكم ولد فلهن الثمن مما تركتم من بعد وصية توصون بها أو دين. وإن كان رجل يورث كلالة أو امرأة وله أخ أو أخت فلكل واحد منهما السدس، فإن كانوا أكثر من ذلك فهم شركاء في الثلث من بعد وصية يوصى بها أو دين غير مضار، وصية من الله، والله عليم حليم. تلك حدود الله ومن جنات تجري من خالدين فيها، وذلك الفوز العظيم. ومن يعص الله ورسوله ويتعد حدوده يدخله نارا خالدا فيها وله عذاب مهين.
صدق الله العظيم. We thank Allah for the benefits of the Quran. This is the month of Ramadan, the month of Al-Quran. And the best thing that we can be listening to is Al-Quran. So that summarizes the chapter of the Quran that discusses what we are focusing on this morning. So may Allah bless us with the blessings of the Al-Quran. Let me quickly recognize the presence of so many personalities that have joined us. I will not be able to mention so many now, but I can recognize some of them. So we have with us our chairman of this today's dialogue, in person of Honorable Justice Kadi Masoud Oniye. So we are grateful for joining us. The guest lecturer is also here, and our discussants are also here. I also recognize the presence of Honorable Justice Kuranga and my good brother, Sheikh Olongbebe, and my other very many friends who have joined us. So we thank you so much for giving us your time. So may Allah accept from us as an act of ibadah. So now the next on the agenda, as we can see, is to talk about MUNFIQ and why this dialogue that we are starting today. Alhamdulillah, let me quickly just brief us that in an effort to also contribute further our quotas to the progress of Islam, so we saw the need for us to promote Islamic finance more in terms of advocacy, in terms of enlightenment, and in terms of giving people access to even understand the benefit for them and how to explore joining the Islamic finance sector. So in the light of that, MUNFIQ Academy was conceived, and MUNFIQ Academy itself is just an offshoot of a larger company, which will be undertaking some very important Islamic finance services, which is MUNFIQ Islamic Social Economic Solutions Limited. I remember somebody asked me that with the looking at Islamic social economic solutions, that why do they not register it as an NGO? And I told the person that NGO is for not profit making. So what we want to engage in, we be in a business like, even though we also be imparting, and that is what we call Islamic social enterprise. So we want to use MUNFIQ Islamic Social Economic Solution Limited to be a model of how Islamic social enterprise or Islamic social business can be practiced, so that we can go beyond theory, which is very typical of those of us who are in academic. So we want to go into practice to also demonstrate what we also theorize, so that people can see how we can also explore even the aspect of Islamic social economy, which are ordinarily regarded as a non-profit, but there's a way we can also explore them without losing their main purpose. So this is idea behind this MUNFIQ. And part of what we want to achieve is to promote Islamic finance, and that is what we are doing through the MUNFIQ Academy. So MUNFIQ Academy itself is not the first attempt that we have made to advance the knowledge of Islamic social finance. We have floated ASWA Academy for Workforce Studies and Research, which is focused and dedicated to the promotion of workful knowledge, specifically. Then we also have Tawakkul Institute of Corporate and Cooperative Studies, which is also dedicated to the promotion of the knowledge of Islamic cooperative society. So why we are having all this separately is just to show that each of these various aspects of Islamic social finance, in terms of their even knowledge and human resource need and training, they can stand on their own, and they deserve separate institutions that will be dedicated to them. So one of the major focus of Islamic MUNFIQ Academy, like we have said, is to promote the knowledge of Islamic finance. And for that reason, we have floated Islamic Finance Fellowship, which is a free fellowship by which we are mentoring the participants to see how they can be properly guided into to go into the field of Islamic finance, various fields that may interest them. And we have been able to attract, as we see in the clip we are going to play, we have been able to attract scholars, mentors from various parts of the world, from Malaysia, from the UK, from the Gambia, from Mauritania, and even from the outcome. So we have mentors who have volunteered and supporting us in this regard. So we started the fellowship in January, and inshallah it's going to end in October. So we want to make it a sustainable project, and that is why we have deemed it fit that MUNFIQ Academy should also begin its business aspect, which we are going to launch very soon, inshallah. So you can watch about the MUNFIQ Academy. So that is about MUNFIQ Academy. So without further delay, let me invite our chairman of this dialogue to give his open remarks. But briefly, let me introduce our chairman. He is Honorable Kadi Masoud Oniye. His Lordship is the most senior Kadi at the Kwara State Shariah Court of Appeal, Ilorin, next after the Grand Kadi now. He is a barrister and solicitor of the Supreme Court of Nigeria. He was a seasoned legal practitioner with the Kwara State Ministry of Justice in Ilorin for so many years before his appointment to the bench of the Shariah Court of Appeal. His Lordship is an expert in Islamic inheritance and the author of one of the famous and widely read and circulated book on the subject in English. On this note, let me inform that as Allah will have it, part of the intention was to invite, as the chairman of this dialogue today, our father, the late Honorable Justice Ahmad Ambali. Allahu Akbar. May Allah forgive him and overlook his shortcomings. If I were to be present in Nigeria, he was the first person I wanted to invite because I know he also was an expert in this field. But because I couldn't reach him, so that is why I thought that another Kadi that I know is also very dedicated to the inheritance is Honorable Kadi Masoud Oniye. So we pray to Allah to accept all the good deeds of our father, Honorable Justice Ahmad Ambali, overlook his shortcomings, and admit him into Al-Jannah Firdaus. Honorable Kadi, you are welcome, sir. So you can kindly unmute yourself and open your video for your opening remarks. I've made you a co-host. You can unmute. Oh, I hope the network has not signed him out. I understood that he might have some challenges, network challenges. So I don't know if he's back so that he can give his opening remarks. Otherwise, we pen him down till when he's able to join us back later. So on this note, let me quickly move to the next on the agenda. So if you are not able to get his Lordship, so I've initially made him a co-host. I think maybe network has signed him out. Okay. Okay. So we move to the next on the agenda, which is the dialogue presentation. And let me introduce our guest speaker today in person of my brother. In my department, we are in the same department at Kwara State University. And we have so many unique members of staff in that department with a unique spelling of names that you can hardly write their names without making mistake. So he happens to be one of them. Is brother Ahmed Abiodun Mohammed. So that is the one we can write very well. But this one, Mikael Esquire. So he had his university education at the University of Ilorin, where he obtained LLB degree in Common and Islamic Law in the year 2008. So he attended the Lagos campus of the Nigerian Law School in 2009, where he bagged BL and was called to the Nigerian bar in the same year. He obtained Masters of Law degree from the same University of Ilorin in 2014. And in 2020, he bagged a professional diploma in education, PD, from the prestigious Kwara State College of Arabic and Islamic Legal Studies. So since he was called to the Nigerian bar, he has been very active in private practice and works with some reputable law firms, both in Kwara State and Lagos State, such as Clerk Paiko and Co., Abiodun Dada and Co., Shakirullah M. Obale and Co., and Niyidowu Law Chambers. In 2018, he was sworn in as a notary public for Nigeria by the then Chief Judge of Kwara State in person of Honorable Justice S.D. Kawu, retired. Mr. Mikael is a law teacher at the Department of Islamic Law, Faculty of Law, Kwara State University, Malete, Nigeria. He is a member of some reputable association. Thus, he is an associate fellow of the International Institute of Chartered Educational Practitioners, member, Teachers Registration Council of Nigeria, member, Nigeria Association of Law Teachers, member, Nigeria Association of Islamic Law Teachers, member, Academic Staff Union of Nigerian University, and graduate member, Nigeria Institute of Management, member, Nigeria Bar Association, and member, Muslim Lawyers Association of Nigeria. Mr. Mikael has authored many articles published in local, national, and international journals. He has also attended some conferences, seminars, workshops, both physically and virtually. His areas of research interest include Islamic corporate governance, Islamic inheritance, among others. In 2021, he obtained professional certificate in Islamic estate distribution from Al-Hikmah University, Ilorin, which is the first Islamic faith-based private university in Nigeria. So on behalf of all the management of MUNFIQ Academy and all the audience here present, and those who are absent, for whom I'm holding proxy, I have the honor and privilege to invite our brother Mikael, to proceed to make his presentation. So you have 30 minutes to do the presentation. So you can kindly unmute yourself and open your video. I'm going to bring down my own screen sharing, so you can proceed to share your screen. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullahi wa barakatuh.
Okay, kindly set your camera so that we can see your face very well and you can share your screen.
Assalamu alaikum wa rahmatullahi wa barakatuh. Please, doctor, am I being heard? I want to confirm that, sir.
Yes, wa alaikum salam wa rahmatullahi wa barakatuh. We are hearing you loud and clear.
Alhamdulillah. Alhamdulillah. A'udhu billahi minash shaitani rajim. Bismillahir rahmanir rahim. Wa salatu wa salam ala rasulullah wa ala alihi wa ashabihi wa mawala. Alhamdulillah rabbil alamin. Ar-Rahman Ar-Rahim, Maliki Yawmiddin. We thank Allah subhanahu wa ta'ala for counting us among his servants that will witness this noble Ramadan. We pray Allah subhanahu wa ta'ala to accept as an act of ibadah. And we also pray Allah subhanahu wa ta'ala to grant us many more Ramadan on earth. Before I proceed, I want to thank the MUNFIQ Academy for giving me this opportunity to share my little experience in this aspect of Islamic law. So our topic for today is simply MIRATH and MURUR ZAMAN, inheritance, litigation, and defense of statute bar from Islamic law perspective. Now, by way of introduction, it is important.
Sorry, Brother Mikhail. Sorry to interrupt. I think my Lord, the Honorable Justice Oniye is back now. I think he has network issues. So let's quickly take his chairman opening remarks. So my Lord, you can unmute yourself. I've made you a co-host to be able to do that. I hope he's hearing us. Oh, okay. Justice Oniye, you can kindly unmute yourself, sir. I've made you a co-host. You can unmute yourself and open your video, sir. I think he has challenges with the network where he is. So you can proceed. When he's able to do that, maybe after your presentation, he will make his, okay, he has been able to open now. Okay. Yes.
Hello, assalamu alaikum.
Wa alaikum salam wa rahmatullah.
Are you hearing me now?
Yes, we are hearing you, sir.
Thank you so much. I want to make to speak them permanent post so that
okay, you can close your video, sir. Maybe then to make it better. Okay. Oh, I think the network is not favorable where he is. Sorry, sir. Maybe we can proceed and you give your address later because of time. Okay, Mr. Mikhail, you can proceed. Please share your slide again. So the Honorable Kadi will address us later when he gets a better network. So you can unmute yourself because of time. So please share your slide again. Okay. Please proceed because of time.
Okay. I'm trying to reshare the. So the moment.
Please proceed.
Okay. I will start now.
Your screen is not full.
Now. Yes, I'll make it full now. It's full. Is it showing now?
It's not showing.
Okay.
Please proceed with the presentation.
Yes, it's there, right there. Now, alhamdulillah, like I said before, the topic of today's lecture is MIRATH and MURUR ZAMAN, inheritance litigation and defense of statute bar from Islamic law perspective. By way of introduction, it is important for us to get some concepts clear from the onset. And that is why it is important for us to ask ourselves, what is MIRATH? Simply. So in Islamic jurisprudence, MIRATH means systematic distribution of estate of deceased Muslim in accordance with the tenets of Shariah after consideration of Wasiyah. Wasiyah here means Islamic way. Because under Shariah, before we can conclusively discuss or deal with estate of a deceased Muslim, it is important for us to consider the Wasiyah written by the testator before we move ahead. Because the operative word in the Holy Quran is so meaning that as far as MIRATH is concerned, we cannot deal with it without having to look at MIRATH in the first place. Now, according to the scholar of inheritance, they use one word, that is fara'id, interchangeably with MIRATH. And when this is done, it means inheritance and succession. So anywhere we find the word MIRATH or fara'id, then the scholars are referring to the same thing, that is either inheritance or succession. Now, what is MURUR ZAMAN? MURUR ZAMAN is an Arabic term. It contains two words. First, MURUR, and second, ZAMAN. Literally, it means expiration of time or expiration of a particular period to do certain things. In Islamic jurisprudence, looking at it from technical point of view or from legal perspective.
Sorry, kindly open your video, please. Kindly open your video.
The video is not open here. I have opened it, but when I try sharing the slide, it's close the video. Maybe because of the device I'm using. Can I proceed?
Please proceed.
Like I've said, MURUR ZAMAN is, from legal perspective, it means a principle of law that stipulates that a plaintiff must bring his action within a certain period of time. Otherwise, if he fails to do so, the period will catch up with him, and of course, the claim will not be enforceable again. So it is similar to what we call statute bar under the common law. It is called statute bar because we have statutes that makes provision for such limitation period. But in Islamic jurisprudence, it is a principle that's derived from source of Islamic law. Now, the next concept to understand is inheritance litigation. What is inheritance litigation? Inheritance litigation simply means a lawsuit filed by an aggrieved plaintiff in Islamic court of competent jurisdiction. But what makes it inheritance litigation is the fact that the subject matter of that suit is MIRATH or fara'id. So any suit filed by a particular plaintiff, and we can see that from his claim, is referring to MIRATH or fara'id, then definitely that particular litigation qualifies as inheritance litigation. Then, of course, it can come in various forms, as shown in the slide. We can approach and state distribution, although we have some firms and we have some scholars who are versed in the estate distribution. But of course, notwithstanding this, we can still approach Islamic courts for estate distribution. Then, of course, if a particular distribution has been made, but it contravened the position of Shariah, then that can be a cause of action upon which a particular interested legal heir can approach the court to challenge that particular anomaly. And of course, if there is a long delay or failure to distribute estate of a deceased for no just cause, one of the legal heirs can have a cause of action in this and approach the court to mandate anyone that is proven difficult to ensure that the estate is adequately distributed in line with Sharia. And of course, issue of wasiya, like I've said earlier, when we are dealing with MIRATH, we need to consider wasiya as well. And in wasiya writing, it has certain rules and regulations stipulated by Sharia. That is, the testator cannot write a will that covers more than 1/3 of his estates. That is one. And of course, the law frowns at the fact that the person who is going to be a beneficiary of the will, of the inheritance, cannot be a beneficiary in the will written by the testator. And of course, a testator, even though he has right to write a will in the quantum of 1/3, the will must be for lawful purposes.
Sorry,
if you have some wills,
brother Mikhail, sorry.
Now,
your slide is just stagnant. So I will advise, just close the slide. I'm going to share your slide from this side now. So,
okay.
So just close the one you opened before. I'm going to share from this side now. Okay, thank you. So you can continue with your discussion, please.
Okay. So what I'm saying is that in wasiya written by testator, if wasiya is written in such a way that relates the provision of Sharia, then that can also be the reason for approaching the court, and in that circumstance, that particular will also qualify as inheritance litigation. So we have given some instances under which plaintiff can have claims upon which we can see that, like in any legal perspective, to determine the jurisdiction of the court, we need to look at the claims of the plaintiff. And to determine whether or not a particular claim before the court or a particular action is negligence in nature, then we look at the nature of the release of claims being claimed by the plaintiff. Next is Islamic perspective. This perspective. Like under Sharia, before we do anything, we need to make sure that we are versed with Islamic perspective, otherwise we will not be running foul of Sharia as far as that particular action is concerned. So looking at Islamic perspective is just Islamic law position on a particular subject matter. But of course, it has to be after we have submitted that to analysis of relevant sources of law. That is, for us to know that this is question of Sharia on this particular matter, then we need to do some sort of research from primary sources to know what the question of Sharia is all about. And in this, the concept of maqasidu Sharia. So that is that about Islamic law perspective, because we are looking at MURUR ZAMAN and its applicability in inheritance litigation. Then what is the Islamic law perspective with respect to it? Now, it is, before we move further, it is important for us to know that theory of ownership is peculiar under Sharia. in the sense that we do not have what is called absolute theory of ownership under Sharia. Because Allah is the one that has supreme ownership over all properties. Like in the common law, if you own a particular property, you have the right to deal with that property the way you like. Under Sharia, you cannot do so. That is why Allah regulates our property ownership while on earth, and of course, after our demise. The example of the one done during our lifetime is payment of zakat. If our property was being paid zakat over, then it is compulsory upon us to pay zakat. We cannot say, since I got this property from my own sweat, then I'm not going to pay. No, that is not. So also after our demise, Allah has stipulated how our property is going to be fed, shared, and distributed, and who are going to benefit from that property. That is why the jurisprudence gives the testator some allowance to make will not below or not more than 1/3 of the entire estate. So in the Holy Quran, Allah said, وَلِلَّهِ مَا فِي السَّمَاوَاتِ وَمَا فِي الْأَرْضِ لِيَجْزِيَ الَّذِينَ أَسَاءُوا بِمَا عَمِلُوا وَيَجْزِيَ الَّذِينَ أَحْسَنُوا بِالْحُسْنَى. This is one of the many verses that shows that as far as ownership is concerned, we only have certain extent. Allah controls everything about our ownership of property. That is why after our demise, that ownership, that interference from Allah still persists. That is why MIRATH is very important. And we as Muslims, we need to start to begin to have some sense of perception that after our demise, our estate must be distributed in line with the position of Sharia. The next slide, sir. Now, it is important for us to understand what is MIRATH. MIRATH simply means Sharia approach to estate distribution under Sharia. Sharia approach here means that a specific mode that has been stipulated by the Sharia from the understanding of the Holy Quran and Sunnah. So it is an approach that nobody can toy with. It is an approach that is divine in nature. It is an approach that is mandatory. So that is why in the Holy Quran, Allah made some mandatory injunctions to the effect that if or at the event of our death, this is how our property is going to be shared. And if you look at those from Quran chapter 4, verse 11 and 12, it has covered every aspect, every circumstance that can happen that we can think of. Some scholars have looked at this particular provision. They said, especially non-Islamic scholars, they were amazed that how can in just 1, 2, or 3 verses, then we cover the bulk of estate distribution. That is the mighty of Allah subhanahu wa ta'ala. Now, from this, we need to understand that the conflicting issue of dying intestate and dying testes, as we have it in the common law, it cannot be a problem for us under Sharia. The reason is that I used to tell students that we have 2 types of will in Islamic jurisprudence. We have a will that emanates from the testator, and we also have another will that emanates from Allah subhanahu wa ta'ala. In the Holy Quran, Allah said, وَسِيتٍ مِنَ اللَّهِ. So meaning that the MIRATH, how we distribute estates of a deceased Muslim after his demise, is just another type of will but from Allah subhanahu wa ta'ala. And of course, that particular provision is flexible to the effect that it also gives the testator opportunity to have 1/3 of his estate distributed. But of course, it is not automatic because it has to pass through Sharia tests. Conditions for it must be met. Next slide, sir. Next slide. Now, in the discussion of MURUR ZAMAN, it is important for us to understand the rationale behind the compounding of this principle. The principle is simply that as far as a plaintiff is concerned, in any matter whatsoever, he has limited period of time within which to approach court to seek redress. And if he fails to approach court within this period, his right will be deemed to be extinguished. Although the right is there, but it becomes unenforceable forever. Now, in Islamic jurisprudence, this particular concept is applicable in Islamic civil matters. However, from a number of literatures, two major reasons have been advanced for the applicability of MURUR ZAMAN to Islamic civil litigations. This first one is to discourage nonchalant attitude of Muslims. Because, of course, if a cause of action arises, it is most desirable to approach court of law at a time when the facts are fresh in the minds of the witness, and when all the machineries to do justice in that case is available. Because if we should delay, then a lot of things will have happened. In fact, in some circumstances, the story matter will have been tampered with. And in fact, we have some instances whereby, especially in these mirrors issues, when the nectar is not shared as at when due, definitely after some long delay, the original legal heirs will have exited this world. And then we'll now begin to see case being filed by their descendants. In that circumstance, the court will be confused. So it is important for us to discourage that attitude. To discourage that attitude, the court has made the principle of command has been placed. And the second one is to also discourage laches and acquiescence. Laches and acquiescence simply means a plaintiff that knows that he has a right over some particular property, and he has known that someone has usurped over that property, and he decided to waive his rights for donkey years. In that circumstance, it will be deemed that he has left over his rights. So laches and acquiescence has caught up with him or her in that circumstance. So these are the two major reasons why this principle of MURUR ZAMAN is propounded in Islamic jurisprudence. Next slide. Now, it is also important for us to understand that as far as MURUR ZAMAN is concerned, delay is very peculiar to it. Delay is very peculiar to it. How? Experience has shown that there are some reasons that cause for delay in nectance litigation. For instance, cultural belief and superstition. To some cultures, or some adherents of some cultures, they believe that after the death of a deceased Muslim, the next thing is not to distribute his estates. They believe that after Janaza, when you begin to talk about how the estate is going to be distributed, that is a show of hatred for the deceased Muslim. So they believe that we must give respect, we must mourn the deceased Muslim, and we must abandon his estate for a while before we can begin to think of whether to share the estate or not. So this superstitious belief has to be erased from our memory. And of course, it is as a result of ignorance of the law. If we are versed with the law that as far as death of a Muslim is concerned, part of the way that we need to wind up his existence on earth is to make sure that with the position of Shariah. Also, one of the reasons is the existence of wicked and callous members of this family. At times, when we have uncles, brothers that we have entrusted with their property while on earth, after the demise of the trustee, they can just be wicked with the property, they can seize the property, they can refuse, they can decide not to disclose the existence of that property. And this circumstance, before it could be ascertained that social property is in the hands of social person, we can have a number of them that has lapsed. Also, unascertainable inheritable properties. If you have Muslims that are lived in so many parts of the world, Nigeria, London, England, China, what have you, and we have records to the fact that he has properties in this part of the world. But the problem is that we cannot ascertain where exactly that property is, especially where the testator during his life is so secretive. He kept everything to himself. Nobody knows his secrets. But of course, we are aware that he has property somewhere. So insofar that we cannot ascertain the location of the property, we have to be patient or to be able to have some inheritance. So the length of time we have to wait to be patient, of course, will account for delay in inheritance cases. And of course, busy lifestyle of the legal heirs. We have some legal heirs they live abroad. They even believe that because they are contented, they do not need the properties of their father, not knowing that it is part of their right to have it. Then after you get your share, then you can decide whatever you like it Islamically. So the lifestyle, they don't have time to come down, to settle down, to have a meeting and to iron out how the properties are going to be shared in accordance with the tenet of Shariah. So all these reasons, of course, makes one to believe that as far as inheritance is concerned, in most cases, delay is peculiar to it. Next slide. Now, we are talking about MURUR ZAMAN, then what is Islamic law perspective of it? That is where a plaintiff, or let me say some legal heirs, they have brought inheritance litigation before an Islamic court. Then to what extent can we say, or does this principle of MURUR ZAMAN is applicable to it or not? First and foremost, it is important for us to know that the jurisprudence of Islamic law recognize the defense of MURUR ZAMAN. Like we know, the basic principle in Islamic law of evidence is that al-bayyina al-mudda'i wal-yamin ala man hankaw. Ordinarily, a defendant who is supposedly expected to raise this defense of MURUR ZAMAN supposed to be man hankaw, that is, he who asserts must prove. Explanation is upon the one that brings the suit, while the one that denies should take oath. But in a situation whereby the defendant is proving, asserting that the action that has been brought before the court is statute bar, or it has been caught up by the principle of MURUR, then the first leg of the principle is now binding upon him again to provide explanation. So because of that, he needs to satisfy the court whether or not the litigation is statute bar or not. And from Islamic law jurisprudence, scholars relies on the hadith of Prophet Muhammad, which says, "Man hasa shay'an ashara sanin fahuwa lah." That is, whoever possesses a thing or a property for 10 years, such a person is deemed
Oh, it seems we have lost the network of Brother Mikhail there. Okay, he's back.
Is the owner of that property. Now, from the hadith of Prophet Muhammad, the follower of Imam Maliki, they have espoused a principle. This is the source of their principle of MURUR ZAMAN. Like we know in Islamic law, before we come up with a particular principle, there must be basis for it in the source of law. If you have a principle that has no legal backing in the source of law, that principle cannot stay. So the principle of MURUR ZAMAN is derived from this hadith that says, "Man haza shay'an ashara sinin fahuwa lah." So according to this, Imam Maliki followers, they gave us two samples of situation whereby the principle of MURUR ZAMAN can be applicable to Islamic civil matters. The first is where we have parties, that is plaintiff and defendants. They are not related to each other. That is, when we have a plaintiff, we have a defendant, and we can ascertain that from their relationship, there's nothing like blood, there's nothing like affinity. In this circumstance, the principle can be applicable. And in this circumstance, it's a 10 years limitation period. But where we can ascertain that the parties are related by blood or by affinity, then definitely the principle stipulates that the period of limitation is 50 years to be on safer side for parties who are related. Now, like I've said that al-bayyina al-mudda'a, and it is also applicable to the defendant, because defendant is putting forth some claim to the effect that the the case is started by, then he has to satisfy the court. He needs to provide explanations. So explanation in terms of the conditions that must be met. So on this slide, we are seeing some 3 conditions. This condition must be met cumulatively, that is, 3 of them. If any one of them is missing, then the law is not going to give credence to the defense of statute bar. The first one is that the plaintiff has capacity at the time the cause of action arose. Capacity here means competence to competence to approach the court of law. Where the plaintiff was suffering from insanity, or the plaintiff was a minor. So as far as that is concerned, the court will not give credence to that principle, because we cannot ascertain that at that particular time, the plaintiff has legal capacity to approach the court. Again, the second condition is that it must be proved that the plaintiff has opportunity to seek redress at the time the cause of action arose and he chose not to do so. This is peculiar to our Muslims in the East. We have some Islamic matters that needs litigation, but of course they don't have Islamic courts from where they can ventilate their grievances. So as far as this area is concerned, anytime they have Islamic courts, then they cannot begin to bring a claim to court. If a defendant is now raising defense of MURUR ZAMAN here, the court will say no, because all this period of time, there was nowhere, no opportunity to litigate. So because of absence of opportunity to litigate, then it can also make this defense not to hold sway in law. And lastly, it must be shown that the plaintiff is aware of the usurpation over his property, and of course, throughout the period of the limitation period. So it means that for a defendant to successfully rely on the plea of MURUR ZAMAN, he must prove these 3 conditions cumulatively: legal capacity of the plaintiff, opportunity open to the plaintiff to seek legal redress, and of course, awareness of the plaintiff with respect to the same matter of litigation throughout the time of limitation period, and he chose not to do anything. Next slide, sir. Now, in discussing applicability of MURUR ZAMAN under Shariah, it is important for us to know that this principle is generally applicable to all Islamic civil matters. All Islamic civil matters. If we check the Constitution, we will know that we have what we call Islamic personal law, Islamic personal matters. These are referred to as Islamic civil matters, although we have some other contemporary issues that can still conceptualize under this particular Islamic civil matters. Now, in Islamic jurisprudence, this principle of MURUR ZAMAN is applicable to all Islamic civil matters, to the exception of 2 things. One, al-waqfu, that is endowment, and mirath, inheritance. Where in a particular case, we can feel some ingredient of waqfu, element of mirath, then we need to be careful. In this circumstance, the court will hold back and will not make the principle of MURUR ZAMAN to defeat the purpose of, or the objective of Sharia in this instance. And the reason is that this mirath litigation or inheritance litigation, the law gives it a special privilege. Why? Because it is the right of Allah. It is the commandment from Allah. If Allah commands us to do a particular thing, if you do not have time, no length of time can be an excuse for that commandment. So commandment that estate of deceased must be distributed in line with the way Allah has declared in the Holy Quran is a commandment that must be followed, that must be obeyed. It is mandatory in nature. So if we use or allow MURUR ZAMAN to extinguish cases as symptoms of inheritance, then definitely that purpose of Sharia is being defeated. And of course, it is important for us to know that in the contemporary time, judges have been upholding of MURUR ZAMAN in decidable cases. But of course, exceptions have been given to Waqfu and Mirath. So this shows that MURUR ZAMAN is a good defense open to any defendant in Islamic jurisprudence. But of course, it cannot be applied anyhow. When we are dealing with cases that has to do with inheritance, then issue of MURUR ZAMAN cannot be applicable. Next slide. Now, in Nigeria today, we have evidence of application of MURUR ZAMAN. Then we have this case of Iya Maiwanan versus Mama and Captain. This is one of the cases in which we can see that, because in law, we have statutory provision, we have judicial provisions. Now, from Islamic perspective, hadith that supports the principle of MURUR ZAMAN, and of course, the exposition of that principle by a valid school of law under Sharia. Now, we now have the court case, judicial authority over that particular concept. In the case of Iya Maiwanan versus Mama Captain, it was a case of two brother sisters. The brother ate the property that is subject to inheritance for a good of 30 years. The reason is that the other sister was away, was busy with her married life. So when he come back after 30 years, then he challenged the brother that this matter, she came back to demand for a share of the inheritance. The brother said no. Then it becomes inheritance litigation. The matter was filed before a Sharia court, and this defense of statute bar, MURUR ZAMAN, was raised before the lower court. The lower court looked at the length of time and said, this is too much, it's too inordinate. Because of that, the court struck out the case for the fact that it has been cut off by the principle of MURUR ZAMAN. On appeal, the court said the position taken by the lower court is not the position recognized by Islamic law jurisprudence. Because as far as MURUR ZAMAN is concerned, it is a good defense, but it has its own limitation. It cannot be applicable in cases like Mirath. The court said, notwithstanding the 30 years that has elapsed in this particular case, the sister is entitled to ask for a share under inheritance. So in this case, the court laid the rule to the effect that as far as inheritance case is concerned, that is inheritance litigation, defense of MURUR ZAMAN is not applicable. Even if we delay for 200 years before the case is litigated, of course, that MURUR ZAMAN can never defeat the cause of justice in this particular case. And the underlying factor is the fact that it is a commandment of Allah which has to be obeyed. Next slide. Next slide, sir. Next slide. Now, it is important for note from this discussion that as far as Islamic jurisprudence is concerned, it is desirable to dispose or to distribute the property of deceased Muslim as quick as possible. It is desirable. So the cultural belief and superstition that says that you need to wait for some time before you begin to talk about the property distribution after the deceased Muslim, that supervision does not hold sway under Sharia. Because of course, as Muslims, we should do away with superstitions. Islam is all about light, while superstition is all about darkness. Allahu waliyul ladina amanu yukhrijuhum minadh dhulumati ila nur. That is the position of a Muslim. All sorts of inheritance that is and all sorts of superstitions that is against the clear tenet of Sharia, we should do away with it. Now, it is to be noted that even though delay cannot defeat the objective of Sharia in inheritance case, but that delay is makruh in nature. it is detestable. Why? The reason is that we have a valid idea of supermarket that says, as long as issues relating with inheritance has not been satisfied, has not been properly decided, then the soul of that deceased Muslim in Barzakh will be in abeyance. So if we delay inordinately, then we are not doing a good service to the person who has worked for this particular property. So as much as possible, we need to assist our deceased Muslims by ensuring that after their demise, as quick as possible, we should distribute their estate in accordance with Sharia. The fact that we have said that delay cannot make inheritance litigation to be statute bar does not mean that we should have the nonchalant attitude to now begin to delay. So quick disposition is highly desirable, while delay is makruh. Next slide. Next slide. Now, by way of conclusion, sir. By way of conclusion, it is important for us to know that as far as inheritance litigation is concerned, it is sui generis under Sharia. What is sui generis? It is a particular action in the unique class of its own. It has a separate rules that govern it. So the rules that govern other civil actions cannot be made applicable to inheritance case. That is why MURUR ZAMAN can be applicable to other Islamic civil matters. But of course, when it comes to Waqfu and Mirath, the two aspects are sui generis. We cannot apply the principle of MURUR ZAMAN. And the underlying principle or the underlying condition is that in inheritance cases, we have Haqqul Law, that is right of Allah that can never be waived. Mankind can waive their rights, but the right that is due to Allah can never be waived. So the principle is saying that you have waived your rights, having chose not to file litigation, not to approach court for this length of time. But of course, because of the inherent right of Allah, then it cannot be said to be waivable. It is not waivable. So we need to know that to litigate by inheritance as quick as possible is most desirable. Why delay is what? Is makruh. Now, in form of, by way of recommendations, attitudinal changes is important in this aspect. All these superstitious belief, lifestyle, busy lifestyle, ignorance of the law, and of course, cultural beliefs that is anathema to the principle of Sharia. As far as inheritance is concerned, we have to move away from it. This because while as a Muslim, we must be in the light at all time. So all form of darkness in form of substitution, our superstitions must be avoided. Of course, we need reorientation. Programs like this will expose Muslims to the fact that as far as Mirath is concerned, distributing estates of the deceased Muslim immediately after Janaza is most desirable. So we shouldn't see it as a way of being hatred to the deceased that has departed us. And of course, we need to now begin to seek Sharia inheritance-based resolution from experts. When we're talking about scholars here, we need to be selective in the scholars we approach. We look at the scholars that have valid reasoning from the Quran and Sunnah. And of course, fear of Allah is very important in whatever we do. As parties in inheritance cases, we must fear Allah. Inheritance litigation is litigated just to bring the objective of Sharia to the limelight. So whatever that will defeat the purpose of Sharia, the parties must try as much as possible to avoid it. And of course, proper Islamic upbringing is important here, because if we have trained our children that, of course, inheritance is important. While I'm on earth, I have certain duties with respect to my property. And after my demise, this is how my property is going to be distributed. If they are well, properly brought up in the real and valid knowledge of Sharia, then all this nonchalant attitude, superstition, and the likes will not affect the interest of our deceased Muslims in Barzakh. So in the course of this presentation, some scholars and colleagues, they have been helpful, and I listed them in this slide: Professor Zubair, Professor Smahil, Professor Oba, and our Honorable Justice Emi Uniye, my Dr. Abdullahi Shola, Dr. Aisha, and Mr. Ibrahim T. Omotosho. In one way or the other, they have enriched this presentation, and I want to use this opportunity to acknowledge and thank them immensely. So at this juncture, I want to thank everybody for listening patiently. Assalamu alaikum wa rahmatullahi wa barakatuh.
Rahmatullahi wa barakatuh. Jazakumullah khairan. May Allah reward you abundantly, and count this as part of the into the scale of your good deed. So we pray Allah to increase you in knowledge and oratory power of explanation and understanding. Jazakumullah khair. So without further delay, whoever has questions, we can wait until after the discussion. So we have invited two eminent scholars who are very, very passionate about Islamic inheritance to share their thoughts on this presentation. And of course, we have made the presentation available to them earlier. So I'll be calling on both of them to share their thoughts one after the other. Now, let me quickly introduce them to us so that we can, okay. Okay, our first discussant is our scholar, our teacher and mentor, a respected scholar, in person of Dr. MUNFIQ Ahmad Arikewyo Al-Jauhari. Dr. MUNFIQ, popularly known as Al-Jauhari, is a lecturer at the Department of Islamic Studies, Al-Hikmah University, Ilorin. He is the coordinator of professional certificate in Islamic estate distribution of the University Center for Islamic Heritage. This program, I can reliably inform interested that it's one of the programs where you can be properly groomed in matters of Islamic estate, if you so desire to get your to get some proficiency in that field. And Dr. Al-Jauhari is a very good teacher of Islamic inheritance and also a practitioner. So he is the founder and director general of Atekwa Center for Islamic Wills and Inheritance Execution, Ilorin, Kwara State, Nigeria. The Atekwa Center is reputed with the credit of executing over 60 cases of inheritance across the nation. So Dr. Jauhari is a prolific writer, an expert and specialist in the field of inheritance, and is well known and respected among the specialists in this field. So it is my pleasure, and Dr. Jauhari has written a book, so many books, both in Arabic and English language on inheritance, and so many other areas of Sharia. So it's my pleasure to invite our Sheikh, Dr. MUNFIQ Al-Jauhari, to kindly make his presentation. So I made you a co-host, and for that reason, you can open your video and also unmute yourself, sir. Assalamu alaikum.
Wa alaykum assalam wa rahmatullahi wa barakatuhu. Am I being heard?
Yes, clearly.
Thank you, sir.
Yes, sir.
Alhamdulillah wa salatu wa salam ala rasulillah wa ala alihi wa sahbihi wa sallam. First of all, I want to give a special commendation to our ever active Dr. Abdullah Ishola, who is the founder of MUNFIQ Islamic Finance Dialogue. So we pray Allah subhanahu wa ta'ala to continue empowering you. Most so, I also commend the presentation of the presenter by Barrister Mikhail. In one of my write-ups on Islamic estate distribution, I was able to classify the literatures available on MIRATH into three. We used to have subject material books, and we used to have literature that delves on comparative studies of MIRATH. And we used to have legal practice perspective, which is being led by Dr. Abdullah Ishola recently. I am very pleased to say that with this presentation, Barrister Mikhail has also joined the League of Researchers into the legal practice perspectives of MIRATH. So I pray Allah subhanahu wa ta'ala to make this as a starting point for him. I have 4 points to discuss, which emanate from the presentation of the presenter. Generally speaking, this presentation has more to do with delay of estate execution, because ordinarily, many litigations usually emanate from delay in estate execution. And this has caused the question that many people used to ask, that what is the stipulated time which is given by Shariah for the estate execution of a deceased? Whenever a deceased passes on, what is the stipulated time that we need to execute his estate? So we need to get this right, because in fact, some estate may take 2-3 years and it will not be taken as a delay as far as Sharia is concerned. So we can properly understand this by going with these two explanations. Number one is that MIRATH, according to the maxim of Sharia, it is atabi'u. And we used to have a principle that says atabi'u, anything that is always made to follow it. So you can't just jump into distributed estate without fulfilling other precedents which Sharia has made. This is what our score to be resolved before jumping into the distribution of an estate. So we used to have funeral expenses, then we have debt with its two divisions, the debt of Allah and human debt. Then we have to settle with wasiya. So if these three take us 2 years, 3 years, then we don't have any case to answer for not distributing our estate. It is when we are through with these three that we can say that it is time for executing an estate. Then the second explanation is that we have what we call element of MIRATH. That is 3 ingredients that must be seen and featured before we can be good for executing an estate. We have the heir, we have the death of the deceased, and we have subject of inheritance. Whenever someone dies and there are heirs who are going to be the beneficiary, and we have confirmed the death of the deceased, but we couldn't see what we want to distribute, because unfortunately some people died without having anything to distribute. So it can be that they left some things, but they are not valuable, and anything that doesn't have value in Islam should not be subjected into execution or distribution. We distribute what is valuable, what is convertible to money. My second point is that the presenter quoted an hadith which he used as the basic for MURUR ZAMAN in Shariah. So, and that is the hadith of Sa'id ibn al-Musayyab, man hadha shay'an ashara sinin fahuwa lahu. So, though I have my reservation about the hadith, because the hadith actually features in the literature of the jurists. So it is very difficult to find in the literature of the mu'addithun, the collators of hadith. The reputable hadith pertaining to this course have been reported by Bukhari, mentioning 10 years. And it is noteworthy to mention some of them. The hadith of Aisha, man ammara ardon laysat li ahadin fa huwa ahaqqu biha. So this hadith is being used by scholars to support that anyone who has been occupying a particular piece of land and he has invested on the land with nobody challenging him for some particular or unspecified years. So the person can lay claim of ownership to that set of land. So, and that is why you will see that even despite the fact that the presenter claimed that the view of the followers of Imam Malik is that as limit on from MURUR ZAMAN, who is the founder of the school of thought, does not accept that view. According to the report of Ibn Yunus in Al-Mudawwana, he said that according to Imam Malik, that 10 years is not recognized. What Imam Malik said is that whenever the Waliyul Amr, the constituted authority, has given his consent, then no problem. But about the years, he didn't give any specified years, be it 10 or 8 years. Although some subsequent students of Imam Malik, such as Ibn al-Qasim, so they were the one that adopt 10 years as statute bar. So my third point is about what the presenter said concerning the delay in attending to MIRATH cases as it affects the deceased Muslims at the Barzakh. I know this has become a notion or superstition that many Muslims have been sticking to for a long time. They will always tell us that when a particular estate is not distributed, then the deceased has a share of punishment in the default of the family. Well, so we need to state this clearly, that executing the estate of the deceased is the responsibility of the family, the beneficiary, the bereaved. It is not the responsibility of the deceased. وَلَا تَزِرُ وَازِرَةٌ وِزْرَ أُخْرَى. How would Allah punish someone for an act which he is no more able or capable of exercising? So we need to review this thought. It is a common notion that we Muslims actually believe in, but we need to review it. What we can always say without fear of contradiction is that if the deceased has a hand in the delay of his estate through his action or inaction before his death, then this will be taken as part of what he has done which he will receive the positive result or negative outcome, even when he is at the barzakh. So finally, because of time constraints, the presenter raised an important issue when he was talking about MURUR ZAMAN as not applicable to mirath. So he now made an illah, a ta'lim. He based that notion on the fact that mirath is categorized as a right of Allah. Please, this needs to be reviewed. Though, if you check Quran 4, verse 14, after Allah has made its submission on the formula of inheritance distribution, he said, وَمَنْ يَعْصِ اللَّهَ وَرَسُولَهُ. Yes, anyone who disobeys these rules and regulations will end up in hell. But if we can still give it a second look, we will see that mirrors can also be categorized as Hakul Ibad. Why? Because in any case that is labeled as the right of Allah, what we are saying is that human being does not have a say in it. And if you check mirath, so this is contrary to this principle, because in mirath, a particular beneficiary has a say that what is given to me, I forfeit it to someone else. In fact, we used to have what we call mutual agreement of the heirs. The heirs may agree that this estate, a particular set of estate, we don't want it distributed. We want to use it for it. We all have mutual ownership. So we want to decide that it should be used for something else, maybe for family house, that no one will have a share, an identified share in it. So if it is pure right of Allah, Hakullah, they wouldn't have had such an opportunity. So the preferable view is to say that mirrors is a mixture of Hakullah wa Hakul Ibad, because we used to have 4 categories for the Ukuk in Usul al-Fiqh. We have Hakullah al-Khalis, a case that is pure, undiluted, the right of Allah. We have Hakul Ibad al-Khalis. Then we used to have MUNFIQ Hakullah wa Hakul Ibad. So a case that involves the right of Allah and it involves the right of beneficiary. In mirath, the right of Allah is that it must be distributed according to the template given by Allah subhanahu wa ta'ala. Why the right of human being there is that human being is given the opportunity or the privilege to forfeit his rights according to how he wants it. So, and this is called at-tasaluhu wa takharuj. So reconciliation among the heirs in a particular inheritance case. So I pray Allah subhanahu wa ta'ala to accept this as an act of ibadah from all of us. So finally, congratulations to MUNFIQ Islamic Finance Academy. We pray for more subsequent achievements and outing. Jazakumullahu khairan. Thanks for listening.
Jazakumullahu khairan, Sheikh. May Allah elongate your life and preserve you upon goodness. It's always very motivating listening to you. And I think a lot of issues have been raised. It's just unfortunate that we don't have so much time. But I think there will be another time, perhaps when we can also have some dialogue on even the position of Mirath in terms of even matters of right, whether right of Allah and all that, and which aspect actually fall within the right of Allah, so that we'll be better enlightened to know our limits and constraints in that regard. Jazakumullahu khairan. We are very, very grateful. So we still be requesting that you stay back, because we have some questions and some comments that may arise. So on this note, you can kindly off your video now while I call on the next discussant. Our next discussant is another very eminent scholar and a brother, a respected scholar, our brother Imam Ridwan Jamil. Imam Ridwan Jamil is the chief imam of Lekki Central Mosque. He was born in Ilorin, the capital of Kwara State. He obtained his primary and secondary education in Ilorin. He has a diploma in Arabic and Islamic education from the Ahmadu Bello University, ABU Zaria. After his Thanawiya, he had his first degree in Sharia and Common Law, LLB, from the University of Ilorin, and his master's degree in law, LLM, from the Bayero University, Kano. He is currently a PhD researcher. Imam Ridwan Jamil has authored more than 15 books in English and Arabic, many of which have been published and freely available online for download. May Allah reward him for that gesture. He is an Hafiz, having memorized the entire Quran by heart. Imam Ridwan is married, happily married, and blessed with children. These are some of the cover pages of some of Imam Ridwan Jamil's books. We have so many of them, so I just try to show us some of them. And by his kind permission, we will try to share with us the link to his page where we can download some of his books free of charge. And some of them that are also available for sale, we'll be able to purchase them so that we will enrich ourselves with so many areas of knowledge where he has endeavored to benefit the Ummah with. May Allah preserve him for goodness for us. On this note, I would like to invite Imam Jamil to kindly unmute himself and open his video for his discussion on the dialogue.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Assalamu wa rahmatullahi wa barakatuh.
Bismillah ar-Rahman ar-Rahim. Alhamdulillah wa salatu wa salam ala Rasulillah. We praise Allah, and may the peace and blessings of Allah be upon the noblest of mankind, Prophet Muhammad sallallahu alaihi wasallam. We appreciate Dr. Abdullah for organizing this, and may Allah continue to strengthen you and support you. And for the presenter, Barrister Mikhail, may Allah reward you for your efforts. And for Sheikh Dr. Al-Jawhari, may Allah continue to strengthen you and bless you and prosper your endeavors. It's always very fascinating and thrilling that we see people like you in this field, things related to inheritance and Islamic finance, Waqfu and others. Alhamdulillah, we have been championing this aspect of Islam, which has contributed immensely to the growth of Islamic knowledge, enlightenment, and also for the betterment, economic betterment of people. May Allah subhanahu wa ta'ala strengthen us and grant us the grace of doing it for a long time. I mean, this issue that we are discussing today, the issue of MURUR ZAMAN, inheritance, and the case of the statutes bar, as we have for the limitation law, limitation law in the English law. So it's a very important one. But whenever I'm listening to a lecture or a presentation, the first thing I look at is what's the purpose of the lecture? Then who should be the right audience of the lecture? Alhamdulillah, we have a good discussion, and we have a good number of people who are listening to this discussion, and it's very important. So I appreciate you all. Please, we need to make sure that we go home with some points to which we can develop and also pass the message across to others. The issue of inheritance, so that has been mentioned passingly, that we all know how important the matter is. One thing I would like to mention, as the presenter was talking, when he mentioned that this beautiful lecture, beautiful presentation, that the inheritance distribution could be done by scholars or by the courts. Yes, that's very important. We need a lot of scholars who should, be well proficient about this matter, as we have Dr. Jawhari and a few others. So we need to have many scholars who can train people on this and also who can be practitioners in this matter, because there is much ignorance when it comes to the inheritance distribution, and it's one of the reasons why there is delay in distribution sometimes. And also there is no trust in many people. That is why they may not even want to apply Islamic law to distribute the estate of the deceased. They may even want to apply their own reasoning, or they want to use the English law to do that, or they just fight over it, or they just use Yoruba system, the Ori or Idigi system, which is contrary to the Islamic law. And one of the reasons is that they don't have trust in many people who call themselves scholars, and very difficult for people to really distinguish who are the true scholars and those who are not scholars, those who are specialists in an area and those who are not specialists. So this matter, this area, we need to really create an enlightenment about it for people, and we need to produce scholars on this matter. And under that as well, when I was doing my PhD research, when I was in Kano, I visited some courts. So I learned that generally the courts, the scholars are discouraged from even undertaking the distribution of inheritance. So scholars are only allowed or encouraged to do fatwa on inheritance. But when it comes to distribution, actual distribution, it is considered as qada, and preferably that should be referred to the courts, so that the courts can make decisive legal judgments on the distribution of the estate, and it will be recorded. So because of subsequent litigations that may arise out of the distribution, once the case is filed at court, so then it puts a hand to it. If there's any litigation, we can always refer to something. Unlike that the scholars distribute, which may not be certified, and which may still bring up some issues later. So they used to advise scholars that even if they undertake distribution of estate, they should still encourage the heirs to go to court for ratification of what the scholars have done, which is a very important point. And I will want us to into this matter to also encourage people that they should go to courts, the area court, especially where we have one. So they should encourage people to always go to court, and where scholars distribute, they should possibly certify it or give a kind of award, as is done in arbitration, whereby when you have an arbitration is concluded, you issue an arbitral award for those who have approached the arbitrator. So this is very important. Another thing is that has been clarified. When the debts that a person who dies had incurred before he died, different from his estate, it is debts that may affect the person after his death. Like the Prophet ﷺ said, "Nafsul mu'min mu'allaqatun bidaynihi hatta yuqta'an." So the soul of a believer will be held in abeyance, will be held hostage until the debt on his neck is paid off. So that affects only the debt part of his estate. So, but the estate, as it was explained before, so it doesn't affect the distribution or otherwise, doesn't affect the soul of the deceased person. Once a person dies, all the estates, after removing the debt and the wasiyah, everything that he leaves behind doesn't belong to him anymore. So it's not, it's only questionable for how he gathered the wealth hereafter. But how to be distributed, that is left for the heirs to determine. So if you delay the distribution of the estate, is like you may be suffering yourself, especially if you are in need of money and you have inheritance estate that you can distribute and you don't even distribute it. So you are the ones suffering yourself. And Islamically, we don't have to allow wealth to lie idle. The Prophet ﷺ used to say, "Man kana lahu ardun falyazra'aha aw liyamna'aha man yazra'uha aw liyada'." Anyone who has an arid land that is lying in waste, to try to plant something there, or you should give it to somebody who can plant something there. So the Prophet used to encourage that we should not allow wealth to lie idle. So the same thing, we should not delay inheritance if you don't have any Sharia reason for that. And then to also fall in line with what the presenter has concluded on, that the issue of statute bar does not affect Islamic inheritance. Yes, so it doesn't affect it. I remember in the case of Muhammad ibn Muhammadu, so there was a case that some heirs were denied inheritance from the farmland and grazing land of their father. Women were denied to inherit anything from the grazing land and the farmland of their father. They were only allowed to inherit wealth and money and other things. So this case was brought to the upper Shariah court in Kebbi State, and it's decided that no, they don't have any reason, the brothers don't have any reason to deny their sisters from inheriting such. So, and they must be considered as part of it. It was after 36 years when this matter was brought, and the court decided that no, they are entitled to inheritance, they must be given something. This case was appealed to the Kebbi State Sharia Court of Appeal, which affirmed the decision of the lower court, and when it got to the Court of Appeal, the same thing, it affirmed the decision of the other courts. So, which shows that this case was not statute barred just because it was 36 years before the case was brought. So, even though there is an important okay, before I move to that, the hadith, I think it has been clarified that the hadith, man has a shay'an ghayra an ashra sinin fahuwa lahu. So that hadith is not considered authentic according to scholars. If it would have been authentic, then it will have been a very important one upon which many rulings will be based. But this does not apply. Then the issue of the issue of a statute bar or limitation law, as we have limitation law of Lagos and other states, for example. So it's only based on the legal policy. It's legal policy so that people can be encouraged to do things on time. They should not be negligent upon their rights. So if they know that the court will not entertain, will not listen to certain cases after a number of years, at least that should motivate them to do the necessary thing on time. So that is the policy, legal policy, which is based on ijtihad, and it can change. It depends on time, jurisdiction, and the people. So it changes. So that is why it is allowed, because it's under there is something scholars call taqiyud al-mubah. When we have something that is permissible, so you can regulate the permissible things. You have the right to go to court and claim your rights, but there should be some regulation to this, so that the courts will not be, be burdened with so many cases, especially cases that have a good number of years that lapsed over. So to encourage people not to be negligent on their rights, that's why that policy is obtained in some places. So it's based on ijtihad, that is the personal reasoning or the discretion of the state or the government. But that does not absolve the person from spiritual responsibility. So even where that applies, it may not apply in the case of inheritance. If where it applies, it doesn't mean that anyone who knows that he is holding on to the right of another person, it doesn't absolve him from spiritual responsibility with Allah subhanahu wa ta'ala. This is why Ibn Nujaym in Al-Ashbah wa Nadhahir would say that Al-Haqqu la yasqutu bitaqadum zaman. The same thing Ibn al-Qayyim rahimahullah also said, that there is no, the Al-Haqqu la yathbutu bitaqadumi az-zaman, that a long period of time has passed over a particular right does not mean that the person has lost his right. So it has not lost his right. But generally, where that policy is obtained, that is limitation law, so it's applicable just to discourage people, like I said, and also the courts must also listen to certain cases, because there are exceptions to this law as well. It's like in the court when you have the false judgment, that a person who has been served the writ of summons and the person doesn't appear in court within a particular time and doesn't have any reason, doesn't proffer any reason. So the judgment may be given in respect of the plaintiff who had come. So, but it can be set aside if the other party, the defendant, can come and convince the court why he had delayed in responding to the writ. So the same thing applies to this. But the point we are driving home is that anyone who knows that he is having the right of another person with him, Allah will hold him responsible for it hereafter. So even though the court does not entertain that case is because the court wants to discourage people from disturbing them or from or delaying fighting for their rights. But with Allah, this must always be determined, and it must always be examined. So nobody can get away with the rights of another person. As the Prophet sallallahu alaihi wasallam said in the hadith of Al-Muflis, that somebody would come back to Allah with a lot of good deeds, but he also comes with a lot of sins. He has been unjust. He has unjustly consumed the wealth of another person. He has beaten this. He has lied against this. He had done so many things, and all these people you have wronged, so will be redressed on the day of resurrection by taking your good deeds for them. So until there will be some people who will have no good deeds, and the sins of other people will now be taken and piled up on them. So for lawyers who are amongst us and those who are not lawyers, we should know that the limitation law, even though it's adopted as a policy by some governments and some jurisdictions, it doesn't mean that with Allah, the person who benefits from such limitation law will be absolved from spiritual responsibility before Allah subhanahu wa ta'ala. May Allah subhanahu wa ta'ala guide us. All right. Barakallahu fikum. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh. Jazakumullahu khairan. We understand that the Imam will be having another meeting now, so we'll be excusing him, and we thank him so much. Jazakumullahu khairan. So now, let me call on the chairman to give his remarks now. I think he's back with us. Honorable Justice Oniye. Assalamu alaikum. Oh, he's gone again. I think he has some network issue. Okay, now, okay, he's still with us. You can unmute yourself. I've given you permission to be able to unmute and open your video, sir. Okay. Do we have a contribution from the floor before we read out the questions that have been sent through the chat? Meanwhile, I want to inform the audience that we have sent the form to fill for your attendance, and that will be used to issue the certificates of attendance. So you can kindly click that link and fill the form so that we'll be able to send you your certificates of attendance. So if anybody has a contribution to make or clarification or comment, you can kindly indicate by clicking the hand raising button. I hope I'm being heard. Okay. Okay, let me ask Mr. Lukman Abdul Karim, please unmute yourself. Please go ahead.
Assalamu alaikum.
Wa alaikum assalam wa rahmatullah.
Now, may Allah bless you for all, and may He add this in the scale of our good deed. My question, my own go with question, because when Dr. Jawhari was giving the speech, so there was a time when he quoted something that was atabi. So I want him to deliberate more on this issue. And then secondly, he talked about usul fiqh. He said that in Islamic foundation, we have three things to go with. That is haqqullah, haqqul ibad, and then he mentioned the third one. I didn't hear that one, so I want him to just deliberate more on it. Thank you, sir. Jazakumullah khairan.
Okay, Amin. Okay, he will do that. Let's listen to others who also have contributions so that we can take it together. Mr. Taiwo Mutuatanda, please unmute yourself and make your contribution.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh.
Jazakumullah khairan for the dialogue series. My question relates to the will. Please, I want to know, in terms of execution of the estate of the deceased, from the presentation, are we saying the will, that the deceased should have done a will, and that the will only relates to one sort of of its estates, these are estates, which can only be distributed to people who are not beneficiaries of his inheritance, and the remaining will now be the one that will be shared based on the Sharia principle. So I want to know if I get the proper understanding there. Otherwise, I will need clarification from the lecturer. Thank you very much, sir.
Okay, thank you very much. Let me call on the chairman to kindly unmute himself and make his. Okay. Okay. Wa alaikum salam wa rahmatullahi wa barakatuh. Oh, so.
Assalamu alaikum. Are you hearing?
Yes, we are hearing you, but the network is just fluctuating.
Sorry, you know, the network will not be that good.
No.
I have some remarks now that you can help me read it out, because
okay.
I know the network can go anywhere from now.
Okay.
I have been joining and exiting as a result of the network. But I want to commend the initiative of MUNFIQ Islamic Finance Dialogue. I know that I will have an opportunity when I will my own little contribution, but my little remark is as I could I have sent it onto the chat. Please help me read it out, the host.
Okay. Okay. I will read it out now.
Thank you.
Okay.
This part, you are familiar with
yes, I understand that where you are now, you have pre-informed us. Yes. So the Honorable Kadi Oniye, the chairman of this dialogue, has sent this message to us that I most sincerely commend the laudable effort of Dr. Ishola, the host, for expanding the frontier of keeping people abreast of this all-important area of Islamic law. It is an important area because application of fees is fardu ain, but acquiring the know-how of the actual distribution is regarded by scholars as fardu kifaya. Be that as it may, it is the provision of the Sharia that estate distribution and administration of a deceased Muslim must be attended to expeditiously immediately at the death of a deceased Muslim, meaning that there is no too soon after the death. However, as regards the standing up of a legal hear for a complaint regarding an estate, which could be over non-distribution, improper distribution, qualification of any of the heirs, etc., in the court of law, whether such claim can be affected by what the common law balance is called time bar or statute bar or limitation of time or any other names called. So it's or any other names called. I'm sure the speakers have been doing justice to the POSA vis-a-vis the Sharia variant of the time bar statute bar known as MURUR ZAMAN. Although schools have extrapolated from the Sunnah that MURUR ZAMAN applies to other Islamic civil litigation, same, however, is not applicable to MIRATH and Wasiya case. This primarily is because the delay in making the claim is based on peculiar circumstance of each case, and it will not be just to clinch onto another person's right on a flimsy excuse of length of time, as is the case under the common law. Sharia is for justice at all times. However, inordinate delay should be discouraged. May Allah provide another opportunity where I can hear my little contribution, where I appreciate all the presenters and the participants. Assalamu alaikum. Jazakumullah khairan. So we are very grateful and we really appreciate all your effort despite the challenges in the network. So now let me also read out the question in the chat box, which I would like Brother Mikhail and Dr. Ajauhari to take together. That if the heirs they have an uncompleted building to inherit, and they decided not to share it because when they share it, they know they don't have the means to complete that building. Their failure to share that property will it constitute a delay in the distribution of estate. So I think majorly this is the question that we have at the box chat. So I will try to check others, but let me give room to Brother Mikhail to respond to issues that have been raised and the questions. Please, we have just a very few minutes left to conclude this session. So Brother Mikhail, please unmute yourself and make your remarks.
Assalamu alaikum warahmatullah.
Wa alaikum salam wa rahmatullah wa barakatuh.
Did not hear that question properly. It was called, the network was confusing. Maybe you should read it again.
Okay, while I will do that, let me call on Dr. Jawari if he was able to get the questions to make his own remark.
Thank you, sir. Yes. I have two questions here. So okay. The first question has to do with a maxim that says atabi'u tabi'u. So the questionnaire was asking about more elaboration on the principle. So because of time constraint, so the principle entails that there are some instances that whenever Sharia asks you to do something, so you don't need to jump into doing that thing, but you have to comply with what has been laid down to be done before doing that thing. Let me give an example. You can't observe prayer without doing ablution. Whenever you do prayer, then you now say you want to bring ablution after prayer, then your prayer is null and void. So the same thing applies that you want to distribute an estate. After that, you now start talking about debt and wasiya. So having known that you have to settle matters concerning debt and wasiya, anything that remains after that is what we used to call estate that must be distributed. So that is the meaning of atabi'u tabi'un. So it means that anything that has been made to follow a process must follow that process, and you must not cause misarrangement. So the first should come first, while the second should come second. So the second question has to do with the classification of Allah's right, hakullah. So then we have akul ibad, human being right. So the third one is ma ishtaraka fihi akullahi wa akul ibad. That is the mixture of Allah's right and woman's right. So that is the third classification. Thank you, sir.
Okay, Jazakumullah khairan. We have two more people who raised hand, and after them, we are not going to entertain more contributions because of time. Because as we proceed to deliberate more, there will always be more issues to be agitated. So I want to take it that these are the two other people that also have something that they want to clarify. So let me call on our brother Ustaz Abdullah Alikila to kindly make his contribution. And thereafter, I'm going to call on my brother Hakim Saraki.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullahi wa barakatuh.
We thank the organizer of this event, the host of this meeting, Dr. Abdullah Salam. May the Almighty Allah reward him abundantly. We have been knowing right from the youth, when we were youth, that is going to make it to the top one day, and inshallah you will make it to the top. My question is that I want to distinguish between the will, Islamic will, and MIRATH. Is it permissible for a Muslim to write his will, accommodating all his estate? That is the first question. If it's permitted, and if it's not permitted, which degree, which volume of the estate can be making will upon it? I think I'm making myself clear.
Yes, yes. Yeah.
Thank you, sir.
Okay, thank you very much.
Thank you.
So I hope Barrister Mikhail and Dr. Ajauhari, they have noted the question. So Brother Saraki, kindly unmute yourself.
Okay, Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullahi wa barakatuh.
Yeah, let me join others to appreciate brother Barrister Ishola for this effort, because this is one of the important issues in every Islamic home. In fact, my question, let me just go straight to my question. My question is a bit of personal. My grandfather died in April 1966. And if we are going to look at the date now, it's about more than 50 years now. And I can authoritatively tell you that his estate and everything that he left behind has not been shared up to this moment. Now, I want to ask, I understand the first speaker when he said distribution of property should be done immediately, almost immediately. Now, what is the position of Sharia, looking at the distance, the duration of our own situation for over 50 years? What is the position of then that's number one. Number two, what would you advise? What would you advise that the children or the grandchildren should do Islamically? Because he died as a Muslim, and he left all the children as Muslims, though some of the grandchildren are now Christians, but all the children, to the best of my knowledge, all the 17 children are Muslims. And some might have been, the grandchildren now. So that's number. Then, in addition to that, do we now have the opportunity of bringing this case to the Islamic way of sharing property? There's no litigation on it anyway. Everybody has been calm, everybody has been peaceful. They will talk about it, but not taking it to, and not taking any legal process or action on it. We are just cool, we are friends and that. But whether we are good or not, the law of Allah supersedes whatever relationship we want to or we are sharing. And so, please, I don't know if I'm coordinated enough for the speakers and to be able to get what I'm trying to say. First, the year has been long. What is the position of Islam on that, and what is the judgment of the position of law? Then, two, can still this case be brought to the Islamic way of sharing? Let me mention that it was reported that he has a will, that he has written a will, which some of us think might not be, but let's agree. So let's now look at another perspective that he wrote a will. Now he wrote a will. Can we set aside the will and say, okay, let us bring this? Because some people have been talking about Islamic sharing, and some people have said, no, it cannot be, since the issue of the will is there. Thank you very much, sir.
Okay. Jazakumullah khairan. I hope Dr. Jawari and Mr. Mikhail have listened to the question. Let me read out other questions in the chat box so that we can take them together and try to round up this session. There cannot be an end to issue that will be agitated. So we hope that we have another moment when we can have much more questions on inheritance to engage on. So what is the validity of distribution done by the heirs themselves according to Sharia without inviting scholars or going to court? Then at what time can the heirs relinquish his shares? Must it be after distribution? Please, where the many heirs relinquish their right to one or two other heirs before distribution, what ratio would the remaining two heirs use in distribution of the estate, especially if they are male and female? So then, how should inheritance law take effect on a car which is subject of hire purchase where any of the party dies before the discharge of the agreement? So interesting questions there. Mr. Mikhail, I hope you can hear some of the questions. Kindly react to them within 2 minutes.
Yes. Now, assalamu alaikum to the barakatuh.
Wa alaikum salam.
Now, on the question relating to quantum of the will that a testator can write, the principle is that a testator cannot write beyond 1/3 of his entire estate. So he has a limit to what he can write will over. So invariably, he cannot write a will to cover the entire estate as far as Islamic law is concerned. Then, of course, on the validity of wills, distribution done by the heirs themselves in accordance with Sharia without involvement of any scholar. So this is simple. If the distribution is done in accordance with Sharia, then there's no problem. So it is valid as far as I'm concerned. It is only when we can point out that certain Sharia principles or tenet has not been observed, that is when we can begin to raise issue, which if not resolved can resort to litigation. So if we have among the legal heirs that those are vast in Sharia and in the knowledge of distribution of estates, of course, they can call themselves, if there's cooperation among them, they can do it within themselves without involving any scholar. In fact, anybody that is able to, or the heirs, if they're able to do it themselves, they are scholars themselves. So if among the legal heirs, they are able to distribute themselves in accordance with Sharia, then it is valid. Then on the issue of when certain legal heirs negotiate their shares, must it be done before the distribution of the estate or after the distribution of the estate? The one that is safe, that will not put us on serious confusion, is that relinquishment should be done after the estate has been distributed. Because let us just look at the fact that we have so many properties, and then these are the shares, fractional shares available to each legal heirs. Then after it has been done, then the one that wants to relinquish his share to others can now do so. Otherwise, if we leave that particular, if that relinquishment should be done before the distribution of estate, it's going to cause a great confusion. So I am of the view that if there's going to be any relinquishment, it should be done after the estate has been distributed. Then whatever share that has been given to you, you can now relinquish it to any of the legal heirs. Yeah, you wish to do so. And of course, with respect to inheritance that has taken over 50 years, as pointed out by one of our brothers shortly. So that is the focus of this particular discussion. That is, no length of time can defeat the purpose of Sharia as far as MIRATH is concerned. They can still subject that particular properties to Islamic or Sharia approach of distribution. However, he mentioned that there was some sort of understanding that their father had written a will, probably English will. So if we can ascertain that their dad was a Muslim, then we need to make sure that the will that has been written English way should not be allowed to hold sway, meaning that we have to throw that one aside. And then the implication will not be that the estate should be distributed in line with the Sharia tenets. So if a will has been written and it violates the lay down procedure, lay down rules and regulation, of course, it's going to be disregarded. We can have valid and invalid will. So if the will is invalid, then it is of no moment. It will be regarded as null and void. So in this circumstance, if the dad has written a will that covers the entire estate, then the position is that that will is going to be jettisoned. while we now focus on the entire estate to be shared in accordance with Sharia tenets.
Okay,
So
Brother
I think that's all about that.
Thank you very much. In
Yes, sir.
few minutes, Dr. Agyauhari, sorry, we are run out of time. We have to be rounding up. We have even exceeded the time scheduled for this. So in view of the trend of this dialogue, I think there will be need for us at a time to have a dialogue that will specifically be open to entertain some practical questions that we may have. So inshallah, we are going to look at that, and I hope and believe that our doctor and other facilitators will always respond to us when we call on them again. Dr. Jauhari, your remarks and responses to other questions, briefly, sir.
So, thank you, sir. Barrister Mikhail has attempted many questions. I think the only question left unanswered is that of uncompleted building. So, well, the answer to this is that the heirs have to make a decision on that uncompleted building. Not saying that we don't want to share it. No, you may not share it as uncompleted building, but you can dispose it, then you now share the money. So that is what they must do, but not saying that they will not share it. They may run into the injunction of Allah that they are not doing what Islam is asking them to do, and that is the distribution of the estate. So when you are not okay with the uncompleted building, convert it to money, then you share the money. Assalamu alaikum.
Wa alaikum salam wa rahmatullahi wa barakatuh. On this note, we want to thank everyone for your cooperation and support towards the success of this first in the series of Islamic Finance Dialogue. So I want to inform that all the questions that were not attended to, we have them in our record. And inshallah, when we are able to organize another question, please, we are not entertaining any further comment, please. So when we have the opportunity, so there will be the first question to be attended to, inshallah. Why I will call on the director of MUNFIQ to give the vote of thanks and closing remarks. So I want to, on behalf of MUNFIQ, present this certificate to Brother Ahmed Abiodun Mohammed Mikail for being the guest lecturer at this MUNFIQ Dialogue, Islamic Finance Dialogue. So this is just a token way of expressing our appreciation for your effort, and we pray Allah will reward you abundantly. In the same vein, we also present this certificate to our dear Sheikh, Dr. Nafi Ahmad Al-Jauhari, for being one of the discussants. Despite very short notice, we appreciate this. So may Allah accept this as an act of ibadah. And we also present this certificate to Imam Redwan Jami in appreciation of his also being one of the discussants which have benefited all of us. And of course, we have a certificate for our Honorable Qadi Masoud Oniye for his own support as well. We understand that it's currently in a location where the network is not so favorable, but he was so committed to be part of this dialogue. So may Allah reward him abundantly and preserve him and secure him wherever he is. So Jazakumullahu khairan. This is the end of this MUNFIQ Islamic Finance Dialogue Series 1. Assalamu alaikum wa rahmatullahi wa barakatuh. So I'm called on Brother Barrister Orisa Koko, the director of MUNFIQ Academy, to kindly give a vote of thanks and closing remarks.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullahi wa
barakatuh. Thank you very much, Barrister Abiodun Mikail, for your time, your expertise. We truly appreciate every bit of it. Sincerely speaking, quite a number of non-lawyers, not even talk about lawyers, non-lawyers have been very, very much educated and well enriched about the status of limitation of time when it comes to litigation of inheritance. We appreciate this, and we do appreciate, we do want to appeal to you that this discussion may not likely end here. We intend to take it beyond this point. So inshallah, we might be calling upon you again to come and have another look at a similar topic. We do expect that you will be there to support Islam by educating the Islamic Ummah. Jazakumullahu khairan jasa. And I want to appreciate Dr. Jawari. Thank you very much. I'm so sorry if I tap you Islam and massacre your name. I'm so sorry. I didn't intend to do that. Kindly pardon me. Thank you very much for your contribution. We truly appreciate it. The angle from which you have looked at the topical issue. Jazakumullah khairan jasa. And to our Imam, Jazakumullah khairan jasa. We appreciate you for the enlightenment and your contribution to this discussion. Thank you very much. Jazakumullah khairan jasa. And to everybody as well, thank you very much. And Ramadan Kareem. Thank you so much.
Jazakumullah khairan. On this note, I'll be calling on everybody to open their video and have some shots from this presentation. Jazakumullah khairan. You can open your video now so that you can have some nice shots.
الله كان عليكم رقيبا وآتوا اليتامى الطيب ولا أموالهم إلى تقسطوا في اليتامى فانكحوا ما طاب لكم من النساء مثنى ورباع فإن لا تعدلوا فواحدة أو ما ملكت فإن طبن لكم عن شيء منه نفسا فكلوا هنيئا مريئا ولا تؤتوا السفهاء أموالكم التي جعل الله لكم قياما وارزقوهم فيها واكسوهم وقولوا لهم قولا معروفا وابتلوا اليتامى حتى إذا بلغوا النكاح فإن آنستم منهم رشدا فادفعوا إليهم أموالهم ولا تأكلوها إسرافا وبدارا أن يكبروا ومن كان فقيرا فليأكل بالمعروف فإذا دفعتم إليهم أموالهم فأشهدوا عليهم وكفى بالله حسيبا للرجال نصيب مما ترك الوالدان والأقربون وللنساء نصيب مما ترك الوالدان والأقربون وللنساء نصيب مما ترك الوالدان والأقربون مما قل منه أو كثر نصيبا مفروضا.